There are some underlying regulatory principles that have to be kept in mind when looking at the bar or any agency. First of all, I think it's appropriate to understand that we've had a transformation in this country of a political organization. We've grown into what I call a horizontalized structure, where professions and trades are organized around a profit stake in public policy in peer group combines. You have the insurance industry, you have teachers, you have lawyers, you have others, all organized around their own group, and it's part of their group, and they lobby for their group, and they have tribal identification with their group. They defend their group. They look at the world from the perspective of their group. And I think you have to understand that dynamic, first of all, when you look at the regulation of anyone. You have to be aware that the goal here is to understand why we regulate. We regulate because we must have a prior restraint on the practice of certain people who may cause irreparable harm. Doctors, lawyers, and others can cause irreparable harm if they're incompetent. In order to make sure they're competent, we have a barrier to entry, a licensing system, to ascertain their level of competence and to make sure they maintain that competence, revoking their privilege to practice if they fail to meet the standard. That's the concept here. We have a lot of regulation we don't need. They try to regulate aerobics instructors here in California, aestheticians, and so forth, and all sorts of people, which we generally oppose. Regulation can have an anti-competitive aspect to it, and in fact, all of these groups, these horizontalized groups I mentioned, are themselves potentially an antitrust violation in action. A former antitrust prosecutor, I'm kind of sensitive to this, having prosecuting these cases for 9 years, and we have a doctrine called the Norr-Pennington Doctrine that allows them to collude, to lobby government, to persuade government, and that's very important to keep in mind, that there is this exception from individualized competition that allows these horizontalized groups to have enormous impact, really to govern. They're the stakeholders, and the legislatures have become increasingly passive, and they pretty much cater to the stakeholders as they meet in combination. We have the regulation of 29 trades and professions in California, as well as other regulation, of course, which we've been monitoring for 33 years. Having people who are part of a tribe regulate the tribe on behalf of the general body politic is problematic, in my view. The key is to somehow create a system where the governors, the people who are imposing these costs, these prior restraint costs, in the interests of competence and interest of limiting irreparable harm, you want to make sure that they combine expertise and independence. That's the trick, because a lot of people with expertise do not have independence. You've got to somehow find a way of creating a system that combines those two elements. In the case of the APA and the discipline of other trades and professions, the system is very poor. It involves typically 5 steps to discipline somebody, say a physician or a contractor or an accountant. 5 steps. Step number 1 is a hearing in front of a Minister of Law judge, which can be a high-quality step. Minister of Law judge is really performing a judicial function, although they're technically in the executive branch. They have the trial, the hearing. They hear the evidence. They view the witnesses. They make a decision. Unfortunately, that decision is simply a proposed decision, which then goes to the board, commission, or bureau head. That person, and these are people who can often receive what are called ex parte contacts, that is, private communications from people with an interest in the business of that agency. Unlike a court, which cannot do so, they sometimes will do so. And in any event, it goes to the board, commission, or bureau chief, and theoretically they should not be engaged in ex parte contacts, but the enforcement mechanism to prevent it from happening is weak. In any event, it goes to them, and they then make a decision on an independent judgment basis, and they completely rewrite the decision of the person who's a professional judge, who's independent, who has measure of expertise, based on nothing but their own view. They then write whatever decision they want. It then goes to the Superior Court for what's called a petition for a writ of administrative mandate review, which is independent judgment review. Again, these two people are not seeing the evidence, they're not seeing the witnesses, they're not gauging the fact-finding in the same way that the ALJ can, who sits in the actual hearing. That decision can then be rewritten. Then it goes to the Court of Appeal by right of appeal, and then by petition of the Supreme Court. The Administrative Procedure Act guides, in general, all agencies except the State Bar and the Insurance Commissioner and the PUC. All the other agencies are guided by this Administrative Procedure Act. There's a federal one as well, and there's a state one guiding the state licensing of state business professions and trades. and most of that regulation is not federal, it's at the state level. That's why we focus on the state, because the state is really where the action is in terms of regulation and consumer protection, much more than the federal jurisdiction. So when we looked at the State Bar Court, and I was able to fashion the State Bar Court system in a manner that's very close to what I wanted, we attacked those problems. We attacked the problem, first of all, by saying, okay, we're no longer going to have the old system. What was the old system? It was horrible. The cases were being tried essentially by early on in the system by examiners in the field. That's the competitor or the friend of the accused, because lawyers know each other in a community. Then it would go up eventually for an appeal to a review committee of 18 people who would sit there and meet occasionally and allegedly decide whether or not this discipline should stand and how the decision should read. The Supreme Court then reviewed every single case. It reviewed every single case because the process was so sloppy and inconsistent that it felt it had to. And it did review every single case, and it took up a lot of its caseload. And they started making sarcastic comments in their decisions about the quality of the cases they were receiving. That was about the time the legislature appointed the State Bar Discipline Monitor position, which I then held for 5 years, which is as long as it lasted, in order to fashion reports and change the system. So what did we do? First of all, we said, okay, we're going to end this system where the profession controls its own discipline. We're going to have a judicial system that's independent. It's going to have expertise, because these judges are going to know about the law, and they're going to know about the expert information that's necessary. They're going to have at their disposal. So we're going to have 6 hearing judges. That's how we originally proposed it. 6 hearing judges, all appointed by the Supreme Court. We'll have a 3-judge panel, also all appointed by the Supreme Court. They won't be affected by the horizontal profession and its desire for money. They will be part of the judicial branch, in effect. There'll be a 1-step petition for review to the Supreme Court, just like in a criminal case. It'll be 3 steps. It'll be people who are independent, people who are knowledgeable. It'll be efficient. It won't be 5 steps. It won't be forever. There'll be an interim remedy that can be imposed if you need that immediately. And we also included in the system other ingredients that are very important that are not in the APA system for other agencies. Number 1, the bar receives all sorts of information about its licensees that others do not receive. If there's something bad in court or you're sanctioned, it's going to go to the State Bar immediately. If you have a malpractice judgment, it's going to the State Bar immediately. All sorts of information flows into the State Bar that other agencies do not receive as a matter of practice. We have a special channel where the judge can call the State Bar and let the bar know that their attorney is causing a problem. So we have all those things going on, which are very important progress. We have interim remedies that can be interposed to protect the public in situ while the situation is going on, while the pendente lite, the case is being prosecuted. We have all sorts of other checks and balances that have never been there before that make it a much improved system, and in many ways the landmark ideal system for national replication in other states. Having said that, that doesn't mean I'm contending that it's flawless or that there aren't problems, and in fact serious problems. I don't want to be someone who says, well, I created something that's got to be perfect because I was involved in it. I'm not that way at all. My wife will tell you I'm very critical of everything I do, and if I'm not, she is, so it makes up for it. There are some things about the system that I don't like, a fair number of them. The first problem is the Office of Trial Counsel, the ones who are being the attorneys, the people who are actually making the key decisions, whether to prosecute or not to prosecute, and what to prosecute for, and who to prosecute, are still under the aegis of the Bar Board of Governors, not separate and independent as the State Bar Court is. So the State Bar Court is independent, but it doesn't help a lot to have the State Bar Court independent when the people who are deciding what's going to be prosecuted and what's going to be charged are not. They are under the aegis of a Board of Governors, or have been under the aegis of a Board of Governors, controlled by practicing lawyers. So attorneys, the tribal group here involved, the horizontalized collegial group, is actually selecting their governors on behalf of the public, operating on behalf of the public. That is not acceptable. That is a form of basic fundamental corruption in my view. People say, socialism, socialism, socialism is horrible. Well, there's one system that is clearly worse. It's called industrial socialism. That's where the state doesn't own the means of production. The means of production own the state. And when the means of production, with the conflicts of interest, control the body politic with a broader interest, a diffuse interest, a long-term interest, you've got the ultimate corruption. And that's what you have with the State Bar or any agency that is dominated and controlled by the group that's supposed to be regulated and constrained on behalf of the body politic. So that's my thesis, and has always been my thesis for 32 years, more than 32, 40 years, in advocating on behalf of consumers. We were able to get a major change in 2011. It's now taking place. It's a very important change because it lessens the problem with the Office of Trial Counsel being controlled by the profession and making all these decisions vis-a-vis a laudably independent state bar court. What's the change? It's not far enough, but it's pretty far. Starting right about now, it's now in transition, no longer going to be 23 members of a board of governors, 17 selected by attorneys, with only 6 public members selected by public officials. It's going to be 19 members on a board of trustees. I like the change, by the way, in the name, because they used to walk around calling themselves governor, and that, of course, it made them feel good, but that's, they put it on their resume and everything, but that's not really what their role should be. So they're members of the board of trustees, and of the 19, only 6 are selected by attorneys now. The other 13 are appointed by public officials, by the governor and by the state legislature. On the downside, 13 of the 19 are supposed to be attorneys. We'd like to see that change. We'd like to see six attorneys and 13 non-attorneys rather than the opposite. We'd like to see that. But we do have a system where at least the profession isn't selecting the supermajority of their own regulators. So that's a big plus, a big change. I'd still rather see the prosecutions handled by the state AG, state attorney general, than by the bar, so long as the bar has this much influence from attorneys. If you created a bar which had a majority of public members and nobody selected by the profession, I would say, fine, okay, you control the prosecutions. That isn't there yet. So that's one problem that's critical and important. Other problems. There are other problems with the state bar that bothers me. Number one is cost recovery. We are of course pro-consumer, pro-prosecution, pro-get the bad lawyers out, and so forth, very much so. But we are also aware that there should be due process, there should be fairness. The bar can make mistakes, has made mistakes, and there should be a check on what they do. You always want to have a check. So cost recovery, if it is too assiduously interpreted and enforced, and the way cost recovery works with the bar, it can be very onerous. If you're a respondent in a case, an attorney who's accused, and they even prove a small number of things about you that you did improperly, they can maybe impose very, very high costs on you beyond your own expenses for your own counsel, if you have one, that might impede your willingness or even ability to contest the charges. And that worries me. That worries me when other agencies do it as well. The medical board, we've gotten the medical board to lighten up on the cost recovery so that accused doctors can have a chance to defend themselves without having credit ruination and bankruptcy attend even the sustenance of a minor charge of those that have been levied. So we want to do that. We want to make sure the bar does not overkill on cost recovery. The statute is too wide. It gives too much latitude. It's too punitive in that sense and ought to be changed. I'm concerned about the small firm focus. I'm concerned, and this is something that was mentioned in the other documentary. I'm concerned about some of the things that were mentioned in the previous documentary. When you have respondents who are complaining about how they were treated or the result of their process, their version of what happened may not be entirely complete or correct. There are some examples, I think, and I think some of them were in the documentary, where I also have questions about whether or not the bar did what a lot of prosecutors do, and that is ride the horse. You're on the horse. You're going to overcharge it. You're going to over-prosecute it. You're going to show that you were right. And there is a tendency for prosecutors to do that. I mean, I was a prosecutor for 9 years. I know a little bit about that. There is a tendency to do that, and there is a need for a check on prosecutors. And I can see that. That's why I don't want excessive cost recovery. I'm also aware that the bar has to have an annual report to the legislature, and it has to go to the legislature every year to get its dues, unlike other agencies that have a different kind of procedure that is not as legislative connected. The state bar has to go to the legislature and say, please give me money for next year, every year, and set the amount every year. Other agencies have a ceiling, and they can administratively go up to the ceiling themselves individually. The bar has, please, please, please. That's why we were able to get our reform through, by the way, because we did it on their bar dues bill, which they couldn't oppose because otherwise they're out of business. So we got it into that bill, and we're able to effectuate a radical reform that none of them would have ever countenanced, would have ever signed off on if they had any choice or if they had a separate bill they could kill. But they couldn't kill the bar dues bill. So once the committee members that we were friendly with and that were listened to us put it in the bill, they were stuck. But it has a downside. The downside is that because you're doing this every year and you have to do a report every year, you want the report to look good. One of the ways to make the report look good is to have big numbers. Lots of lawyers being disciplined, etc. The way to have lots of lawyers being disciplined is to take small cases, small firms, people who can't defend themselves very well, and to take cases that are easy to prove. So there can be, in a situation like that, a bias in favor of that dynamic. We have a Chief Trial Counsel, Jane Kim, who's pretty competent, who's pretty good, who's pretty ethical. I think she's going to probably gravitate away from that as much as she can, but the system of annual reports, numbers mattering, has an impact. It has to have an impact, no matter how well-meaning or well-intentioned or bright or fair a prosecutor is. The system itself yearns for higher numbers because that's what the legislators are looking at, unfortunately. They shouldn't be, but they are, and other people are as well. We had 6 hearing judges in the State Bar Court appointed by the State Supreme Court. We had 3 review panel judges appointed by the State Supreme Court at the appellate level. One of those had to be a non-lawyer. John Burton, in his bill, over our opposition, got enacted a bill that changes the hearing judges from 6 to 5 and has only 2 of them appointed by the Supreme Court. The other 3 are appointed by the governor, the Speaker of the Assembly, and the Senate Rules Committee, respectively. So now you have the other branches, more political branches, involved in selecting some of these judges, and I don't like the idea of politicians selecting judges. Especially Assembly and Senate folks selecting judges. I don't like that. It makes me very uncomfortable. And he wiped out the one non-lawyer on the review department and the review panel, which I think is wrong. We had a non-lawyer there, and he was excellent, outstanding. And in Europe and in much of the rest of the world, they don't even have juries at all. They have a judge and 2 laypersons sitting up there making the decision. That's a model which works all over the world pretty well. And so why not use that? So we wanted to use it. We got the support from the bar presidents to do it. We did it, and now a politician comes in and to give more authority to his friends and colleagues, to have them get some appointments, changes it around, and that's a backtrack. Yes, I think Lisa Perlman was a fine judge. I think that she did a very nice job. I opposed her being removed. I supported her and was discouraged that she was removed. And I also agree that over time, having a financial source of money that is in the control of those who are on one side of a legal case is a problem. And I think that it's important for judges to have sources of money that do not create conflicts of interest. And it's not just this example, there are other examples. There are situations, for example, where it used to be that the budget of the superior courts here were very much influenced by the County Board of Supervisors because you didn't have a statewide court system. It was handled county by county, and the judges are sitting there, and they're supposed to rule against the county because the county is a major player in a lot of cases. Someone challenges a writ of mandate, challenges the county, one of his practices, and here you're going to issue a ruling against someone who's deciding your budget. That is something that has always been a problem. That's why we have statewide court funding now, just for that reason. And I think the same logic holds for the State Bar Court. Ideally, theoretically, it's supposed to be somewhat independent now and not directly tied to the decisions made by the Chief Trial Counsel or whatever. But I think that a criticism that it should be separate, structurally separate, is a good one. I would certainly vote for and support and advocate for the separation of the State Bar Court budget so that it is separate and distinct and completely removed from any possible influence from the State Bar. First of all, if you have a jury in State Bar Court proceedings, it would slow it up, it would create more expense, and it wouldn't help the attorneys at all. The message of that documentary is that the jury would be a check on overzealous prosecution. I think the judges are a better check than a jury would be. I don't think a jury is going to be sympathetic to an attorney. If the alternative were what we had 3 years ago, 2 years ago, versus the Department of Consumer Affairs doing it, I would vote for the Department of Consumer Affairs doing it, absolutely. Clearly I would. Right now it's a closer question. It's a closer question. I probably would not oppose it because you still have 6 people appointed by the lawyers, and I don't think that's right. You still have a majority who are, supermajority who are lawyers, and I don't think that's right. And if that would end, if they're over in the Department of Consumer Affairs, I'd be for putting them over there. And so I would not oppose it if you could change the lineup of who's regulating. If you're not changing the lineup of who's regulating, I don't think it matters. In other words, the key variable here is not so much whether there's a DCA head sitting there bureaucratically over you versus the Supreme Court Chief Justice. The issue is who are the governors, who are the board members making the decisions. And if you go over the DCA and have a board which is also selected by attorneys, consisting almost all of attorneys, you have the same problem. So the transfer of the DCA is not in and of itself the final answer or the key determinant here. I want to mention the fact that there's a tendency not to focus on things that the tribe assumes is part of the practice. In other words, there is a tribal bias here that is not even recognized by the people who have it. What is a tribal bias? Example: attorney's fees. How many cases do you find where any attorney is brought before the bar because their attorney fee billing is too high, because they're charging for hours they're not expending? Because their rates are too high, because they change their rates. Anything having to do with billing is not really seriously discussed in general in the state bar context. Or how about deceit, lying to your client and lying to the court about even points and authorities, writing points and authorities that are so intellectually dishonest that they're scurrilous. They're just not even bona fide. How often are those raised up, and how often are those the subject of discipline? Never. Now let me say a few other things. I want to say a few other things that are important. What is the purpose of licensure of attorneys? Arguably, it's to prevent irreparable harm that comes from incompetent practitioners, dishonest or incompetent practitioners. So we have the prior restraint of before you can practice, you have to take a bar exam, you have to prove, you have to do this, you have to do that, to subject yourselves to us, you have to be admitted to the bar, and so forth. That's the purpose. Let's keep in mind that's the purpose. Problem number 1, in order to assure competence of attorneys, we give them a single examination at the age of 24, 25 for 15 or 16 hours, 20 hours. It used to be 20 hours. I think they're reducing it now, but it used to be like 20 hours of exam. And that's it for the rest of your damned life. For the next 50 years you practice. And are you going to practice in an area in any way relevant to that exam? Answer, no. 80% of you, 90% of you are never going to come across anything that's in that exam. You're going to be a bankruptcy attorney or an immigration attorney or a poverty attorney or a criminal defense attorney or an antitrust attorney in any one of 50 different narrow areas. And you're never going to be tested in the area where people are relying on your competence, relying on your competence such that if it doesn't occur, if it doesn't exist, they suffer irreparable harm. They're immigrated back someplace they're in prison, they're whatever. You've got, if you take seriously what you're doing, you key your public protection system to protect the public from what the danger is. And when you're in a profession where a single decision of the Supreme Court can change your advice and change your approach, you must be aware of those decisions. You must be kept up on it. The bar has a continuing legal education requirement, but it has nothing to do with necessarily the area you're practicing in, and it is not enforced with any kind of testing. There's no reason in the world why people should not be licensed in an area where they're practicing and have to take tests every 5 years to make sure you still know what's going on. That would be a system where you could be assured of competence. We don't have that, because the system that has this prior restraint that flunks 60% of the people who take the bar does not in fact key itself to providing the raison d'etre for its existence. It could do so, but it doesn't do so because the tribal rule is we're in. We're in. The drawbridge is up, and let's go. You have the issue of, okay, what happens if someone does do bad? What happens if someone does cause injury? What happens if it's irreparable harm plus reparable harm? And you need damages, and you want to bring a malpractice case. The bar does not require attorneys practicing law to carry malpractice insurance. Physicians, as a practical matter, have to have it, or they're not going to get into the hospital. Hospital will require it. Lawyers, not so. 20% of the lawyers of this state run around without any coverage, which means that if they screw you, no plaintiff attorney is going to bring a malpractice action because they know they can't collect. So the bar has what's called a client security fund, but it only covers dishonesty. It does not cover incompetence. So in other words, you're there to preserve and assure competence and to prevent it from happening, prevent incompetence from happening, and prevent the irreparable harm that flows from it. Not only do you not do that, because you don't really assure competence in any meaningful way in the area people are actually practicing, but when they are incompetent and the consumers do suffer injury, you allow 20% of your profession to proceed without remedy, for the consumer. And part of the reform we were able to get through in 2011 was to change the structure of the state bar. We also did something else. We effectuated the application of the Bagley-Keene Open Meeting Act to the state bar. What is that? That's part of the Sunshine Statute of the state. It's the Sunshine Statute that requires that the meetings be public and open, and that there be public comment allowed, and that there be agendas in advance announcing what you're going to take action on, and so forth. It's in there specifically that the Bagley-Keene Act applies, and the bar's rules must conform to the Bagley-Keene Act. We've been monitoring the Bagley-Keene Act for 32 years. We know a little bit about it. We've filed litigation concerning it, and the bar is not meeting the Bagley-Keene Act. And they're contending we are special, we don't have to. It's not meeting it in terms of the meetings by conference call that the Bagley-Keene Act requires conform to certain practices. It doesn't do it. It has closed sessions on bases that are not allowed under Bagley-Keene, and it has this system of committee meetings where a committee will meet with board members there, so that there's actually a decision being made pro forma in advance of the final Board of Governors approval, and so the people who show up for the Board of Governors meeting, actually not Board of Trustees meeting, that's noticed and want to speak to it, are speaking to an issue that has already been decided in a committee meeting where a majority of the board was there discussing. That's not supposed to happen. The Bagley-Keene Act prohibits that. The bar says, well, we can do it. There's a lot of, because we're connected to the judiciary, and there are some differences. The bar does have some differences because it is connected to the judiciary. I grant that. But it also is true that 80% of lawyers are never in court, or very rarely in court. It's also a consumer agency. It's also a consumer protection agency. It's also an executive branch as well as a judicial branch agency. It's a hybrid. And as a hybrid, it should and could obey the Bagley-Keene Act. And to have people who are attorneys and who are supposed to be the trustees, the governors or trustees of the profession, we're supposed to represent the highest ideals of the rule of law. For them to say that this law doesn't apply to us because we don't agree and we're special is especially condemnatory. I mean, you cannot look someone in the face and say, I mean, the ultimate hypocrisy, and say, I'm an attorney, I believe in the rule of law, that's what I'm all about. And by the way, the Bagley-Keene Act, which the State Bar Act now requires we conform to, we don't have to obey it. Really? The legal profession is not covering 80% of the population that would need its services to perform judicially connected and legally connected tasks. It's too expensive for 80% of the population. Legal aid covers a very small percentage a very low percentage, and the federal statute, this is not California's fault, but the federal statute requires legal aid organizations never to bring class actions. They're not allowed to bring class actions. They can't resolve problems, judicial problems that will, and statutory problems that will affect large numbers of the poor, because they're not allowed to form class actions, which is absurd. Now, legal aid entities have been able to do it by underground kind of means, by creating non-legal aid entities. But to have legal aid do that, this is a federal statutory problem, not California's problem, but it is something that should be aware of and should be, I think, in a documentary, I think would be appropriate. The bar should be concerned about the diminution of class action law, which is critical to an effective judiciary. You've got to have a mechanism for large numbers of people to come in front of the courts and to resolve a grievance that is mass in scope. You've got the internet, you've got mass media, you've got people lying. I can give you right now 10 examples of ads that are complete and utter lies that are out there. And because of the Concepcion case, class action law has been eviscerated. Eviscerated. The Supreme Court holding that the Federal Arbitration Act has to be imposed upon the states. These are conservative judges ignoring the sovereign states, and replaces and supervenes all state consumer protection statute and all class action law, and requires individual arbitration, including arbitration agreements which preclude class actions, if it's in any clause of any merchant's agreement or merchant document that is a notice, common and notice provision that is now common, and it's stuck in every provision. In fact, you're committing malpractice as a defense attorney if you're not including a arbitration, no class action allowed clause in your interaction with every consumer that does business with you, and they all do now. And so that means that there's no class action remedy, which means that the only way you can stop a mass offense in a judicial system that's supposed to enforce the law is if a public prosecutor does it, potentially, or if there's some disincentive outside of that. But you're not going to be able to do it. And the bar should be concerned about that. And the bar should be yelling about that. Both sides, defense and plaintiffs, should be yelling about that. You're leaving out of resolution violations of law that are massive in scope. If each one of these persons who has a right to arbitration were to all file arbitrations, which would be wonderful, so we have 50,000 arbitrations and we go into federal court and close it down, that's what kind of has to happen. It hasn't happened. It's probably not going to happen, unfortunately, because the alternative, I mean, what really happens when you say, okay, everything has to go to arbitration is nothing happens, because attorneys are not going to take arbitration cases that have $3,000 at stake. They're not going to do it. And they know they're not going to do it. The merchants know they're not going to do it. The defense knows they're not going to do it. And the Supreme Court knows they're not going to do it. So they're not going to get overwhelmed by cases. They're not going to happen. The system's going to be closed to those cases, which means massive violations are now open season, and that's what's happened in this country. And what the state bar should be doing is yelling about it, as a unit, as a whole group, yelling about it. They should be in the Congress trying to get the law, the Federal Arbitration Act, changed. They should be filing amici briefs. They should be going to the state and trying to get state statutes that somehow may counteract it, which is going to be difficult but possible. Defining unconscionability and so forth. There are things that can be done that it should be doing. It should be doing something about the lack of legal coverage and the lack of legal aid and the lack of pro bono work of the profession. There are some large firms that do wonderful pro bono work. Morrison and Forster has worked with us in cases, and there are other examples of firms that do wonderful pro bono work. But the profession as a whole is very weak, does very little pro bono work. And the legal aid level people are getting maybe 5% of their legal needs met. The middle class is getting 0% of its legal needs met. That is, if you're under $250,000 a year, I don't think you can afford an attorney. I don't think you can afford an attorney. Not in a serious matter. You can maybe get your will done or something, but you're not going to be able to have the $50,000 or $60,000 retainer and the $80,000 following that to pay a typical attorney in a typical kind of litigation matter. If you're making really under $150,000, $200,000, $250,000 a year, you're not going to be able to do it very easily. And that's a huge middle class. That's 80% of the country. 80% of the country is not being served by the legal profession and by our legal system. And we're not addressing that. And the state bar is not addressing that. Not really. It should be.